Good evening, everybody. Keith here, in case you didn't recognize me. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to get on tonight and talk real briefly about the administrative process because a lot of people have a problem with sticking to the administrative process. So I'm going to talk to you about our own little problem here. We have a couple debt collectors trying to collect on a, quote, debt. And so if you watched my posts over the last month since, oh goodness, it's been at least a year and a half these people have been sending us notices. Every so often from one or the other, there's two separate ones. And you'll notice quite a while back, I can't say if it was, I'm going to say about a year ago. Maybe a little, no, it's a little bit longer, maybe almost 2 years. Year and a half. Anyway, there was something that we received from the local clerk of courts. And rather than open it up and see what it was all about, we already knew what it was about because we had already been to court on a supposed debt collector trying to collect a debt. And when I went in as her companion, in other words, her trustee, and she's my trustee in natural life under the true trust. And we tried to ask the lawyer that showed up to validate the debt, which we had tried to do through the mail. All of a sudden, instead of doing a quiet meeting in the side room to try to resolve the issue, upon my request to validate the debt, she got all angry and said, well, we'll have to go in and talk to the judge then. And you have to comprehend, people, if they're not going to validate the debt with you through the mail, and then they proceed and go to court and try to take you to court without validating the debt, do you think they validated the debt and presented that to the judge, but won't present it to us, the ones they're claiming the debt against? We're the ones that asked for it. If they truly believe we are the debtor, then they have to give it to us so we know how to discharge it, how to take care of it, how to balance the ledger. If they're not willing to do that through the mail and they take you to court, they have not done that before the court. The court is working on presumption. And as long as you don't rebut it appropriately, the court process is the validation. This is why it's so important to respond to them. Now, of course, you can go back later on and prove that it was fraud anyway, but that's still a large step in everything you've got to do in the rest of your life to correct your status. So in the administrative process, these people sent out notices. We tried to rebut we didn't rebut anything. We just asked for validation of the debt and made statements confirming that the debt had to be validated by certain means without misrepresentation, false legal forms, whatever, And when they refused to respond appropriately and took it to court, and then they processed it, and then it was processed in court and validated, and the clerk of court sent us something in the mail expecting us to open it to see the order of the court stating that we had to pay these people. We just wrote all the things on it, or I wrote the certain things on it that didn't comply with their correspondence. and sent it back. And we haven't heard from them since. Now, these other two people that we're dealing with for the last year and a half, they wanted to send us something. And of course, this one here, this one is funny. I gotta take my shield off here for a second to read this for you. Because I want you to comprehend, every correspondence from a debt collector is an offer. Some of them offers are written up by stupid people that clarify it's an offer. Hold on. Okay. Admin Recovery Associates LLC is offering you the opportunity to pay 50% of the account balance to close this account. The account balance, and notice the account balance, account and balance are capitalized, means it's a specific account. To close this account, this 50% payment shall be in the total amount of $864.87 to close creditor account number, and then it gives an account number. That's not our account number. Look at that. Creditor account number. That's capitalized too. That means it's a specific creditor account number. That's not their account number, and it's not our account number. It's the account number of the original bank that we got the card for, or the money from. Admin recovery reference number is 501782, and that's referencing their account. They want us to pay 50%, which we cannot pay, we can only discharge, if we accept their offer. So, several times now, we've just written back a real quick little statement. I'm sorry. Or excuse me, we're sorry. Always we, us, and our. We're sorry. We cannot accept your offer. Pure and simple. That's all it takes for that one. That one's simple. These other people, the Portfolio Recovery Associates, however, when they wrote to us, first time we ignored them, they wrote us again. So, okay, now I'm going to correspond. I sent a correspondence in regards to requiring or requesting validation of the debt. They sent us another statement, or another identical letter. Again, I sent them the original response that we sent, plus an additional or an attachment to that response stating that this is the response we received on the initial communication. Now on your second communication, which gives no response or rebuttal to our request for validation, we again request validation. Now, it wasn't worded exactly like that. Again, you can go back through my posts, but that was the basics of it. They turned around, and instead of sending a response to us, they went to the local courthouse. One thing I want you guys to comprehend, the people that we got the original credit from are out of state. It's a different jurisdiction. This portfolio recovery people, they're from another state, another foreign jurisdiction. And upon our request for validation, they entered in a court case in the local court, thinking that if they put it in the local court, we would just show up for court. I don't think so. I entered a cross libel. Now, what happens if the court tries to administrate that case without paying attention to that cross libel? They're going to get their notice. They're going to get their first notice that they have violated, they have committed a tort, a criminal action, because I made it very clear in the cross libel that the plaintiff in this case cannot possibly have personal jurisdiction. Cannot possibly have personal jurisdiction. He has never once, through any instrument, been granted any delegation of authority in any trust. And that's why when they do these debt collections, they're making an offer. It's an offer. Period. Plain and simple. Comprehend that. And you will realize that when they go to court, they're turning it around and saying that it's a validated debt, when clearly they've only made an offer. And the conditional acceptance of that offer is requirement to prove, to validate the debt. If they're not willing to validate the debt and then go running to a court, dishonor. Period. Plain and simple. You have to go to court with clean hands. You have to have a valid debt to present to the court. You cannot use the court as a process to validate a debt. It is still not a debt. It is fraud. So, let's talk about the administrative process. Because the way it's supposed to work is 1, 2, 3. 1, 2, 3 notices. You send your first notice. Conditional notice upon validation of debt. If they acquiesce, you send your second notice. And like I did, I include the first notice and make an attachment showing that it's a second notice. And then if you have to do a third notice, you do the same thing. You use your second one you sent out that has the first one attached, or first one with an attachment. Now you're going to make a third attachment to this one. So now you've got your third notice, which compiles all three of them. Now you've got your proof. You keep all your red registered receipts and green certified receipts, and take your documents to court. And now you file the claim that they're committing a crime. That crime is bringing dishonor in a claim of a debt. They've made an offer many times. Like I said, they're not stupid like this one. Many times they try to sit there and say, well, you owe this debt, and this is a debt collection, this is an attempt to collect a debt, and they then turn around and tell you, well, or have somebody serve you papers from the court. They haven't proven the debt. And if they can't prove the debt to me, what makes you think they proved the debt to the court? They haven't. So, these commercial venues is all for these attorneys. The criminal venue is for you. So when you get your third notice out and they acquiesce, you take all your evidence, you put it together, you file your claim as a tort, as a criminal offense, and you list the criminal offenses. You tell the court what's going on. Then the court can proceed in criminal actions against these supposed, or these people that are claiming some kind of debt and trying to ruin your credit. And that's the crime. They're ruining your credit, which is interference with commerce. They're claiming a debt that they won't validate and then taking it to a court because they know the court works on presumption, so that if you don't show up or respond appropriately, the court's just going to give them their case and say, okay, now you owe them. I'm one of those people, I know they can't collect on certain situations. People on disability, they can't collect. They can't collect out of the trust. And that's what they're trying to do. They're trying to get you to hand over your Federal Reserve notes instead of discharge the debt appropriately through the trust, like I just said earlier in the video. I have no way to pay it. We can only discharge. Comprehend that part. So, the administrative process. 3 steps. If you're doing it with somebody trying to collect a debt through the mail, responses. If you're doing it in court, through a court process like this, you offer them the first notice is going to be opportunity for remedy. I'll accept your offer on the condition that you can provide remedy. If they can't provide remedy and they don't say anything and they don't respond and they still try to proceed with the actions, you give them a second notice. I'm now giving you second notice upon the first notice to provide remedy. You haven't provided remedy. Now you're in default for trying to force me to contract. You're coming with unclean hands. I need to know the remedy so I know the situation is clean. Otherwise, I can't accept your mud. It's dumb. Your third, if they act, and again, they're going to acquiesce, and when they acquiesce, your third response is your opportunity to cure. Now, when they acquiesce at that level, opportunity to cure, now you, and in both cases, whether it's in response to them through the mail, you now have your judgment. You go to court, you place your judgment. That's what I was talking about. You place your claim. That's your judgment. You're going to place an order for execution of judgment. You're going to go out, you're going to try to collect. You don't go physically. You send them a notice and tell them you need to collect. This is the order of the court. Send them a notice of the order. You owe, and if they don't pay, then you have to go back to court showing that they haven't paid and issue an order of possession. This will allow you to go to their property with a sheriff and take their property for the amount of your claim. If your claim's only $10,000 and they've got a car sitting in the driveway and it's worth $20,000, you can take the car, but only to sell it. You can get your $10,000. Anything above that, you have to give them back to them. If that car is only worth $5,000, you can either accept it for $5,000 and run with the car, or grab things to equal $10,000 in value. You have to have assessments on those things, so be prepared. If you're going to go take a car, know how much it's worth. Is it running? Keep an eye on them like they keep an eye on you. Big Brother keeps an eye on you. Keep an eye on Big Brother. These people are working with Big Brother. Make your assessments. Make sure that the value of the property is being assessed so that when you go get the possession, it's going to fulfill your claim. And it's not going to exceed it, so you have to sell it off and give some back. So, back to the court case. Opportunity to cure. So at the local level, like I said, they brought it in this court. This is the court that I'm going to respond to. Court of original jurisdiction, where the claim was originally brought. It is now the federal court. What do you mean? It's just the local district court. No, it's the federal district court now. Bringing my cross libel in admiralty under international law. And this is why I try to tell you people, your local courts are your most powerful courts, because that's where you can bring your international law for the international man. A man that goes and subjects himself to go to the Supreme Court out in some other Washington, D.C., when you get your opportunity to cure, you write up a petition to Congress as your bill of peace. Remember the old cartoon? Some of you guys remember the old cartoon? Oh, I'm just a bill on Capitol Hill. Yeah, present your bill. You got an order. You you went to court. They failed the remedy. They failed the default. They failed the cure. Now you get the order for judgment. Now you get an order of possession. If you ain't got property, bill of peace. Send it to Congress. Pass it through Congress. Congress says okay, they'll send it to the Senate. Senate passes it, they'll send it to the House. The House passes it, boom, there you go. It goes back to Congress. Congress says, boom, pay the man. That's where your trust operates, is Congress. If you want to have any effect on this, I don't have any experience, but that's, through my research, that's the way it's supposed to be done. That's the way it's supposed to be done. Now, the remonstrance that a lot of people are familiar with, sure, that can work. But what's the remonstrance going to do? Remonstrance might get this official to quit doing what he's doing. Might get this official to quit doing what he's doing. Oops. But be careful. Those remonstrances might even get them to change the legislation not in your favor. So think about this stuff. Your administrative process is 1, 2, 3. No matter how you look at it, if you're dealing with a debt collector through the mail, it's 1, 2, 3. If they don't follow that process and provide the remedy, default, or cure, then once you have that information, you can go to court and get an order for execution of your judgment. Judgment's already made. You've got evidence the judgment is made. They failed 3 times. That means what you say must be true. That's the importance of the triptych. I've said it 3 times and nobody's rebutted it. So it must be true, correct? As far as I can say. So yeah, I'm not going into court any questions. I'm going in and telling them this man made a false accusation. He's clarified in, on, and for the record that he can't substantiate that debt because he refuses to validate the debt. Therefore, and I've gone through the proper process, 1, 2, 3. I've given him plenty of times, 21 days on the first notice, 10 days on the second notice, 3 days on the last notice. And you're supposed to have at least a calendar month, which is 31 days, so at least 31 days. And doing 21, 10, and 30, and 3 gives them 34 to make sure you're in the right, coming with clean hands, both time and equity. Once that's done, your next step is either order of possession or bill of peace. Depends on how you want to do it. Bill of peace is the way I would prefer doing it, because I don't care for somebody else's material possessions or anything like that. I don't care to go through the problems. If you have a $2.5 million claim, I don't want to go through the process of auctioning off somebody's $1.5 million property and only getting $1 million and fuck the other $1.5 million off. I'd rather go to Congress and get the whole thing done through the proper trust administration. At least that's my opinion. That's from my research. That's the way it's supposed to be done. Again, I don't have any experience, but I'm working on it. I got a cross libel going. We're trying to correct some records, and that's the best we can do. We're not doing this in any kind of fashion to be detrimental to anybody. We're going forth as peacefully as we can manage, as peaceful as we know, and that's why it's so important to do everything through this instead of standing in court like I did, being belligerent and fingering them, cussing and swearing at them, calling them all kinds of names, calling them communist bastards. They don't like that, and they're going to get aggressive. You do it through paperwork, they can't show aggression. See what I'm saying? Whenever you read something on paper, you don't look at their instruments. Look at their documentation. There's no aggression in them. None. So think about that stuff and realize the administrative process is very important in everything you do. And so when they attempt to contact you through the mail and then all of a sudden stop, You have to continue your administrative process. Our personal take on this in the administrative process is we have made 2 notices to them, and now we filed a cross libel in accordance to the case that they filed with the court. That makes our 3rd notice, because we sent them a copy of our cross libel according to their attempt to go to court. Now they have 3 notices, and we can take that straight to the top if we want. If we want. I'm not ready to learn that part yet. I'm still learning this lower stuff, so I've got to do the next step in the administrative process with the courts on this cross libel, because I need to learn. It's fun for me. Now, it's not near as fun as I'd like it to be, but it's a lot more fun than it used to be. I'm learning how to do the paperwork. I'm learning how to put it in order. I'm learning how to construct it. I'm learning the intent behind it. I'm learning the force behind it. So long as you know how to construct your words and everything, and show the correlations with their codes and everything, and how it's a crime against your man, your body. So think about this stuff, and if I missed anything, I'm going to be reviewing this one. I think it's important everybody comprehend the administrative process. First notice, remedy. Second notice, default. Third notice, cure. If they acquiesce to all 3 of those, and of course now you got a valid claim, you go place your order for judgment, or for order for execution of judgment, because the judgment's already made. They've already acquiesced 3 times. That is judgment. Period. So now you take that judgment to your court. You're not depending on the court for a judgment. You've got your judgment. You need to enforce it now. So you apply to the court with an order for execution of judgment. As long as you're before the court properly, they're going to presume, they better presume, the same way they do in every other case, because there's nobody there to acquiesce. They're going to give judgment. So what you do is, when you go to court on this order of judgment, I believe they'll take your information and certified copy your order to the parties involved, and if they don't respond, now you can go for order of execution of possession. If they respond, then they have to bring reason why your claim isn't any good. They can't come in and say, "Well, we're the ones that had the debt. We're the creditor on this." They can't do that. You've already validated that they refused to respond in the appropriate manner. You've already proven that they made an offer with unclean hands. Period. So comprehend that. 1, 2, 3 strikes, you're out of there, buddy. Batter up! Let's get it. In the meantime, that's it for now. I'll go ahead and post my, edit this thing and add my other platform forums, or forum links, as well as my PayPal link. And hopefully you guys will send me some love. Because you got to know, if it wasn't for you guys, I wouldn't be doing this. God bless you. Love you. Have a great night, everybody.